So some of you might know of a couple of things about Kevin already. He's a managing partner of Martin Law. He's been practicing law for over 25 years with a whole array of individual, civic, governmental kinds of litigation and regulatory measures. He also was elected in November to the Larkspur City Council, and so if we're paying attention, we know Larkspur has some really big things coming up around the Larkspur Station area plan, that Kevin will be a significant member of the deliberations around that. Kevin is also the attorney for the Marin Community Alliance that has the lawsuit for the county, so perhaps we'll hear a little bit about that. I think the thing that we might pay attention to is that back in November of 2012, the IJ published this Marin Voice piece, under the heading, "Housing Plan Should Be Done Right." And I think probably the core theme with CEQA is the way in which we want our building to be done right. So, Kevin, it's a great honor to welcome you here as our speaker. Please join me in welcoming Kevin for some comments about CEQA. Thank you.
Thank you very much. Thank you, Susan. Was this on?
It is on. You have to just hold it up real close.
I'll hold it up real close. Well, thanks for those very...
At an angle. I guess at an angle.
At an angle? Okay,
yeah,
all right.
He's our expert.
Obviously, I'm not. Yeah, you're the expert. I'm not. Right? Okay, put it right up there. Is that a little better? That's a little better. All right. Well, again, thank you, and thank you all for welcoming me so generously today. I really appreciate the opportunity to be before you and talk about what I think is actually a pretty interesting topic, CEQA. But before I do that, I just want to acknowledge the comments that were made about Jim's involvement with Marin Clean Energy. One of the side benefits that I have being a member now on the Larkspur City Council is participation in various regional activities that Larkspur supports. And one of those is Marin Clean Energy, and I'm now very grateful to have the opportunity to be on the board of that entity and learning a lot about utilities and the great service that that entity provides to our community. So it's a pleasure, and I actually see some of my fellow board members here in the audience today, so that's great as well. I'm here, as Susan mentioned, to talk about CEQA, which is more formally known as the California Environmental Quality Act, and recent efforts to do what some people like to describe as CEQA reform. I just want to note at the outset, although you hear that term a lot, reform is not necessarily the word I would use to describe what's happened with CEQA over the years. But it is a term that people like to use and have liked to push. And I just wanted to start by reading to you a couple of excerpts from newspaper articles that were published over the course of the last year encouraging CEQA reform. From April 7th, 2013, just about a year ago, in the San Francisco Chronicle, "It's time to refocus the California Environmental Quality Act on protecting the environment. It must no longer be allowed to become a free pass into court for those whose real agendas involve the ecosystems of their pocketbooks or property values." And then a couple of weeks later, "While this landmark law has done much to protect California resources, forcing policymakers to consider the cumulative and localized effects of projects that meet the letter of all other regulations on the books, it needs revision to stop these shakedowns." It's kind of interesting since I filed CEQA lawsuits. That's okay. San Jose Mercury News: "It is too often abused by a whole range of interests. NIMBYs to protect their personal interests, labor unions as a weapon to demand contracts, and businesses to stop competition, to name just a few. These challenges often prevent development that could create jobs or help businesses survive without harming the environment, and they contribute to California's reputation as unfriendly to business." That was in November of 2012. And finally, from the San Diego newspaper: "The state landmark environmental law has become an all-purpose tool for anyone with an agenda to block construction, business expansion, and much more. Even completely groundless CEQA litigation can tie projects up for years. The fact that Governor Jerry Brown, Senate President Darrell Steinberg, and a bipartisan group of state lawmakers say it's time for substantial reform of the California Environmental Quality Act is good news. Well, I guess. We'll talk a little bit about what happened last year in terms of the efforts that went on in Sacramento to adopt CEQA reform. It wasn't quite as grand as I think some folks who were encouraging that might have hoped for. But before I get into the guts of my presentation today, I just want to add a couple of caveats. Even though I am very grateful to have been elected to the Larkspur City Council last November, I'm not here really to speak in the capacity as a member of the Larkspur City Council. I'm really here to express views of my own, which I'm offering in my capacity as a private citizen and an attorney with an interest in some modest background in the area. I've actually practiced doing CEQA law and litigation for many years on both sides of the table, both on behalf of project proponents and on behalf of those who are opposing projects. So I hope that my experiences kind of reflect the tone of this organization in kind of not being an advocate, but more, kind of down in the middle, just to make sure we're all on the same page in terms of the facts. I'm also not here specifically to talk about individual projects that are going on in Marin County or have been proposed, like the Larkspur Station Area Plan, although I'm happy to answer questions to the extent that I can about that. I'm also not here to talk about pending litigation matters, other than, again, to address questions concerning the status of some of those matters, including in particular the one that Susan mentioned, which is Marin Community Alliance versus the County of Marin, for which I am the counsel of record. But as I said, if there are questions about these matters, and I can get into them during the question and answer part of this presentation, I'd be happy to do my best to try to do that. What I want to do is give you all a little bit of background on CEQA. I'm not going to just repeat the nuts and bolts of what an EIR is, what a negative declaration is, what a mitigated negative declaration is, all of those things. If people have specific questions about the kinds of documents and the review processes that the statute contemplates, we can go into those in the questions. But I really want to just kind of focus on what CEQA is all about, why it is such an important piece of legislation here in California, what have been some of the efforts that have occurred not just in the last year or two, but also over time to modify CEQA. I think that's actually a better term to say reform it. But also focus on some of the legislation that has been adopted more recently, including the CEQA revision statute that was enacted by the state legislature last September, and maybe make some suggestions about what it could mean, at least potentially, to those of us who live and value our lives here in Marin County. CEQA was enacted in 1970 as one of the earlier of the modern environmental laws that we have in this country, both at the state level as well as at the federal level. These were in the days shortly after the first Earth Day, when both the federal government and state governments throughout the country were busy enacting new statutes to protect the environment, including the Clean Air Act, the Clean Water Act, the Resource Conservation and Recovery Act, all at the federal level, and the National Environmental Policy Act, which is the statute that CEQA is in fact modeled after. The National Environmental Policy Act, or NEPA, is a core federal environmental law that sets the national policy of environmental protection. It requires federal agencies to prepare environmental impact statements, or EISs. Under CEQA, we have EIRs. The term in the federal context is an EIS, before approving certain federal decisions having significant impacts on the environment. CEQA serves much the same function at the state and local level here in California that NEPA does at the federal level. It requires state and local government agencies to identify and address potentially significant environmental impacts of their actions, including regulatory actions as well as specific decisions approving development projects. But there are some important differences between CEQA and the federal NEPA statute, as well as other comparable statutes that have been enacted in other states around the country. The most important difference, unlike NEPA, CEQA requires government agencies not only to evaluate environmental impacts, but also to mitigate significant impacts or adopt alternatives that have fewer or lesser impacts. That's a big difference. At the federal level, when you're talking about an equal compliance, you're basically talking about preparing reports, preparing analyses, and providing information to decision makers, but that's it. Under CEQA in California, the CEQA process is designed not only to inform the public and government decision makers, but it's also designed to force action, to force mitigation actions directed at reducing environmental impacts. That's an important part of the process and something that's sometimes lost among both the public and decision makers, but I want to emphasize it all for you today because I view it as actually the most important function for CEQA. In addition to ensuring consideration of environmental impacts, CEQA has an important secondary goal, which I just touched upon, which is public disclosure. The California Supreme Court has stated repeatedly that informed decision-making and public participation are fundamental purposes of the CEQA process. And I emphasize that again. That is a critical part of this process, making sure that you all are well informed, making sure that government decision makers are well informed, and the decisions that are made on the basis of that process are good decisions that not only comply with CEQA, but achieve the goals and aspirations that we have as members of the public. So I like CEQA. I think it's a good statute. It's been around for a long time at this point, as I said, enacted back in 1970. But I think because of these important functions that CEQA serves, addressing environmental impacts, public disclosure, public information, it's really one of the most important environmental laws that we have on our books. And I think it's important that we all keep that in mind as it continues to be under some threat at the legislative level up in Sacramento. Almost since its enactment in 1970, CEQA has been criticized as an impediment to sensible land use planning and development throughout the state. To me, that criticism has always seemed a little bit off base. Almost no one disagrees with the overarching purposes that CEQA is intended to foster. As I said, environmental protection, public participation. To the extent that CEQA requires government agencies to take more time and to be subject to greater public scrutiny for the consequences of their actions, I think that's a good thing. Yet almost from the start, CEQA has been subject to sustained efforts to reduce the amount of time it takes to go through a thoughtful environmental review process and to limit opportunities for public engagement. In the early 1990s, there was a significant push, driven in part by the Wilson administration at the time, to begin the process of quote-unquote reforming CEQA, with several objectives in mind: introducing more certainty and standardization into the environmental review process, focusing environmental review on planning and policy decisions, and streamlining environmental review requirements for individual projects. As a result of that push, CEQA was in fact amended numerous times between 1993 and 2006, primarily focusing on changes on administrative aspects of the statute and on the judicial review process. And we can talk about judicial review. That's kind of a subject near and dear to my heart. Despite these changes, there was a renewed effort beginning in the last couple of years to further reform CEQA, this time not quite so much with a focus on administrative aspects in judicial review, although to some extent. But this time it was more with a particular focus on facilitating the CEQA process to accomplish more substantive policy goals. The first of these efforts was Senate Bill 375 in 2008. Senate Bill 375 is not primarily a CEQA reform statute per se. It mostly changes provisions of the government code, and in particular the planning and zoning law, to link transportation and land use planning to help achieve statewide goals for the reduction of greenhouse gas emissions under AB 32. And I'm assuming most people here know what AB 32 is. That's the landmark California legislation that was passed during the Schwarzenegger administration to among other things, adopt a cap-and-trade program to control greenhouse gas emissions on an economy-wide basis here in the state of California. SB 375 was focusing on ways in which land use planning can help further the goals of AB 32. And it required regional transportation agencies like the MTC that we have here in the Bay Area to include a sustainable communities or alternative strategy to help achieve statewide greenhouse gas targets. It also amended CEQA to some extent to streamline the CEQA review for residential development projects that further those goals. So it did have impacts on some aspects of CEQA, but that was not the primary link. As I said, the primary focus of that legislation was to incorporate considerations of achieving greenhouse gas goals through land use planning and through facilitating certain kinds of transportation strategies that would be consistent with that. The second piece of legislation actually was a series of bills that were passed in 2011, including AB 900, which was designed to streamline litigation for, quote, environmental leadership development projects that provide, again, greenhouse gas reduction and other economic benefits. Mostly what that legislation did was provide a streamlined litigation process for challenging projects of that sort, unlike the typical litigation strategies that people like me sometimes pursue in challenging projects under CEQA, where you go right to the Marin County or other county superior courts. In that case, the amendment was to take that kind of litigation directly to the Court of Appeals.
What was the number?
900. SB 226 was designed to facilitate the installation of rooftop solar facilities and to limit environmental review for qualified infill development projects. It essentially directed the California Office of Planning and Review to develop regulations implementing the statute, which OPR has in fact done. But AB 226 was actually quite a disappointment in many respects to many people, I think, who were pushing for CEQA reform, because in fact it was much more limited than many of the advocates of reform had been encouraging. So that brings us to last year. After some disappointment with the earlier attempts to quote-unquote reform CEQA, last year, and to some extent in 2012, saw a much bigger push, both by industry, by the development community, and by Sacramento, to achieve comprehensive CEQA reform. And many of you may remember this was an effort that was championed by then State Senator Michael Rubio from Kern County, who was caught in some controversy because after he initiated the reform process up in Sacramento, he promptly quit state government and took a job as a lobbyist for Chevron. That kind of took the wind out of the sails of the reform effort when those events occurred. And the result was, in fact, a much more limited but still important piece of legislation, SB 743, sponsored by Senator Darrell Steinberg. A principal goal of that legislation was to streamline environmental review and judicial review of project approval for a new sports complex that was near and dear to Senator Steinberg's heart up in Sacramento, a new basketball stadium for the city up there. But a secondary goal, probably more important for all of us here, was to streamline the environmental review process for certain types of new development projects throughout the state, focusing on infill development projects within transportation priority areas. Just want to summarize quickly what the principal provisions of the legislation are. First and foremost, the legislation requires the Office of Planning and Research to develop regulations, amendments to what are known as the CEQA guidelines, to streamline environmental review of projects within transportation priority areas. One of the things that's kind of mind-boggling when you read this legislation, there's a lot of terms that are specific to the law that are very confusing. There are definitions that are included within the statute to provide some guidance about what it means, but for a short piece of legislation, I think it's a very confusing one. Transportation priority areas are any area within a half mile of a major transit stop that is existing or planned, subject to some definitional criteria under federal transportation law. Now think of that. Something with a half mile radius is actually a pretty big area. I'm thinking of the efforts that we'll be going through shortly, or actually now, on the station area plan down in Larkspur Landing. If you take a a protractor to a map and you draw a circle a half a mile around Larkspur Landing, you include a good deal of Larkspur, Greenbrae, unincorporated Marin, maybe even San Rafael, maybe even Port Madera. It's a big area. OPR is required by July 1st, 2014 to develop criteria for determining the significance of transportation impacts within these transportation priority areas. This is really an effort that the statute charges OPR with engaging in, essentially to revise the traditional ways in which traffic impacts are evaluated within the context of CEQA. The traditional way of looking at traffic is to evaluate the level of service impacts from projects on traffic in the vicinity of the project. That approach to traffic analysis has been criticized as sometimes artificial, misleading. There are some legitimate criticisms that can be applied in that context. And what OPR is charged with doing under the legislation is to develop alternatives to the standard level of service metrics that are used to evaluate the significance of traffic impacts. And they're in the process of doing that now.
Who is the sponsor of this bill? Or who sponsored this bill?
Steinberg. Yep. The criteria that OPR is charged with developing are intended to promote reduction of greenhouse gas emissions, development of multimodal transportation networks, and a diversity of land uses. Once the new rules come out, a government decision-making process that complies with the new criteria will essentially take automobile delay, big part of traffic impacts, off the table in terms of the evaluation of significant environmental impacts. OPR may, but is not required, to develop alternatives to the use of level of service metrics outside of transportation priority areas. So it's basically given a charge to significantly revamp the way in which traffic impacts are analyzed. And they will do that. Another important part of the legislation, which I find even a little more intimidating, is a provision in the bill that states aesthetic and parking impacts of a residential, mixed-use residential, or employment center project on an infill site within a transportation priority area shall not be considered significant impacts on the environment. So, an infill area in this context essentially means, and it's defined to mean by the statute, as a lot located within an urban area that has been previously developed or a vacant site where at least 75% of the perimeter is surrounded by developed or urban sites. This is kind of a worrisome provision. When I think of the most significant impacts that I guess most people will worry about when thinking about whether to approve transportation-oriented development projects, of which many are being proposed, both here in Marin and around the Bay Area, I think of aesthetic impacts and parking impacts first and foremost, not to the exclusion of others. And the legislation is very clear that other potential impacts are not being addressed by the legislation. But think about it. When people worry about new development within our community, what do you worry about? You worry about, is it going to slow you down when you're trying to get to work in the morning? And you worry about what it's going to look like. All you have to do is to read the IJ every other day to see a new article criticizing Port Madera for the Wind Cup project. And what are the two concerns that people universally express about the project? Parking and aesthetics. There may be other communities in the Bay Area, San Jose, Santa Clara County, where we do have significant infill opportunities. There's a lot more intense level of development within those areas. Maybe these kinds of exclusions are a good idea. And I think if you were to ask Senator Steinberg about why he supported this legislation, he would say that he has those kinds of communities first and foremost in mind, not places like Marin County. The problem, of course, is Marin County is not necessarily And we'll see there may be some relief in the OPR regulations that are being developed. But I don't see anything in the legislation that takes Marin County and other similar counties around the state of California out of this calculus. So we're going to have to worry about that as we go through the environmental review process for the station area plan, for other plans that are going to be proposed within Marin County. I think it's a serious issue. And as I said, I don't see anything that's really exempting Marin County from these new provisions. And I emphasize that only because I've had conversations with intelligent people in county government recently who have taken the view, at least initially, that in fact Marin is excluded from some of these requirements because it has a lower population level than some of our other Bay Area communities, and it does. And I think Assemblyman Levine's new legislation to try to get some relief, not under CEQA, but from other aspects of the state planning law, it recognizes that, and that's probably a good thing if it ever gets passed. But in the law, there's not really that, in the CEQA, there's not really that relief that is provided. So it is something that we really have to pay attention to. And we have to be very skeptical when we hear representatives of government agencies and others in the public sphere saying, don't worry, it'll all be okay, when we have opportunities for tremendous exercise of discretion by our elected officials and staff. So that kind of brings me to the real point of why I'm here today. Uncertainty about these new requirements, as well as other provisions of CEQA, and frankly other provisions of law that are implicated in zoning and planning processes and specific development approval processes, makes public engagement in the environmental review process established under CEQA absolutely critical. It's not enough for those of us in this room and for other affected citizens to assume that their interests will be protected by our elected officials, including me, and others guiding the administrative process. It's important to remember that when we talk about the administrative process that governs planning and project approval determinations, there are two related but discrete components that address two related but discrete issues. The first issue is whether a specific planning or project proposal complies with the technical requirements of CEQA and other specific provisions of state law. And that's actually the easier one to worry about, because you just look at what those requirements are, you compare the environmental review documents, and you make a decision about whether they're in compliance or they're not. But the second component of this process, above and beyond whether a project complies with CEQA or other provisions of statutory law, is the project a good idea from the perspective of local community interests and needs? And that's kind of a tougher one to sort out. But they are distinct. When you go through the CEQA review process, you go through a process that will lead to certification of an environmental impact report. When you go through the decision-making process to approve projects, you go through a decision-making process to approve projects. That is a political determination, and political considerations need to come into play when looking at what the opportunities are for decision makers. And it's important to recognize that members of the public have a significant role to play in both components of that administrative process. An informed and engaged public is essential for good planning. Attending meetings like the one we're all here at today is a good first step. It's educational, it's an opportunity to learn, but it's not the end of the process. It's not the end of the process to write indignant emails to elected officials, of which I've been receiving many lately, saying, you must do something about this. Well, what we must do about this is engage in good faith in an administrative process that respects the parameters of the legal requirements with which we must comply, and make sure that everyone in the public has a legitimate and serious opportunity and takes advantage of that opportunity to make their own contributions and make sure that their views are heard. If you all do that, And those of us who are fortunate enough to be in elected positions take our responsibilities seriously, as I think we are trying to do in Larkspur, then that's the best recipe for getting the good outcomes that we can all support at the end. So that's my pitch. Get out there and fight. Thank you.
Okay, let's see. Okay, so this microphone is on. We've got two microphones. We've got about a half an hour for Q&A. We ask that you keep your questions or comments to like a short, try not to go over 2 minutes in terms of your own questions or comments. Doug, if I can slip behind you here. And knowing there's probably going to be many more questions than what we actually have time for. I probably won't be friends with all of you by the end of the day because I won't be able to get to all of you. But I think my strategy is going to be just to kind of start on this side of the room, go table by table, and work my way over to the other side of the room. And then we'll return if there's some more time for that. And then at the end of, half an hour or so, Kevin will give you a chance to give another 2-minute or so summary of whatever you want to say at the end. So, Peter.
Hi, Kevin.
If your name, something, just name, and if you stand too, so the whole audience.
Yeah. Kevin, Peter Singleton, Larkspur, and thanks for your presentation, and I hope that you will vote to reject the stationary plan in its entirety when that comes up. My main concern about the CEQA, the so-called CEQA reform, is not that they define out parking and traffic and things like that, which seems a complete folly. But there's this underlying assumption that's embedded in these pieces of legislation that transit-oriented development is beneficial to the environment. But if you read the comments that were submitted on Plan B area, many of which were submitted by people in this room, those demonstrated that either it's conclusive or that there's at least a significant controversy over whether transit-oriented development does reduce greenhouse gases. So, for example, the mass transit subsidies will not increase transit ridership. High-density housing doesn't necessarily decrease greenhouse gases, nor does actually taking mass transit reduce greenhouse gases. So I guess that underlying assumption doesn't hold, and I guess I'm asking for your reaction to that.
Well, first, thank you for encouraging the outcome of our decision process on the station area plan. I think Ann Morrison was supposed to be here. I don't know if I've seen her. She may or may not have been able to attend today. Let me just give you the standard response that I give to encouragement like that, which is appreciated, and I get a lot of it. So do my fellow council folks. We are starting on a process that will lead to, as I was describing a few minutes ago, political outcomes that respect the needs and interests of our community. I can't stand here today and tell you what my decision at the end of that process is going to be, because that would be unfair to the public. But what I can tell you is that I take it very, very seriously. And for those of you who didn't have enough to do with yourselves last fall and maybe paid a little bit of attention to my campaign, you'll know that I have strong feelings about development-related issues in Marin County. But we are at the start of a process now. That process is not predetermined by the fact that a proposal has been made and that an EIR has been prepared. Draft EIR has been prepared. No outcomes are predetermined in that process. The process is starting as we speak. The EIR has been issued. The public comment period started on Tuesday, April 1st. It will be a 60-day public comment period. There will be at least one public hearing that will occur during that period. I think it's set for later this month, I think April 20th. Not sure of that. But that is the opportunity that I've encouraged today, all of you who have an interest in this, to participate in and make sure your voice is heard. It's not just limited to people who live in Larkspur. Larkspur Landing is at a central part of Marin County in terms of transportation and just geographically. So it's going to affect all of our lives. So it's incumbent on all of us who are concerned about the implications of that project to participate in that administrative process, to make sure your voices are heard and included in the administrative record of decision that will have to be adopted when we're finished with the process.
Okay, any questions? Questions?
You had a
Okay.
second part of your question, but let's go on.
Hello, Sharon Rushton.
Hi, Sharon.
Thank you very much. I was wondering if you could please elaborate on the full CEQA exemption that is allowed by SB 743. And related to that, I understand that the Larkspur Station Plan is within a TPA, and with subsequent projects within that TPA possibly qualify for that full CEQA exemption. Thank you.
Well, I think, it's my understanding, the exemption, to the extent that you want to call it that, is as I described it pretty much in my remarks. Now, I don't know that there has been a formal designation of Larkspur Landing as a TPA. We haven't done it, certainly in the city of Larkspur. I know that that the state has made a survey of candidate sites that could be considered for that, and maybe they included Larkspur Landing in that or not. I don't know that for sure. But a TPA is a pretty big area. I mean, I kind of outlined, I think, what the geographic scope of it potentially could be. The Larkspur Landing Station Area Plan does not extend quite that far. What it does is essentially take that protractor and shorten the length between the 2 points by half, and drew a quarter-mile circle around the proposed station area plan in Larkspur Landing. But that still covers a lot of ground. It covers the parking lot for the ferry. It covers the Country Mart. It covers the sanitary district's property, which has been proposed for development for some period of time. It extends over into my neighborhood of Greenbrae. It is kept out the specific part of Greenbrae where I live, of the Greenbrae Hills, but it includes the areas between 101 and Bon Air Shopping Center. So it includes quite a significant area. And one of the worries that I think your question raises is, over time, as these development projects are proposed, right now we're still in a planning process, that things will create opportunities for kind of grandfathering because, well, we've got projects here, so it's already an urban area, let's have more projects. And that's a big concern.
Okay, question at this table?
Linda Swanson, Larkspur.
Linda Swanson from Larkspur. I think I understand correctly from the City of Irvine case that there are certain, that we have to accept the allocations allocated by ABAG. My question relates to what beyond that do we have to accept? What beyond the allocation set by ABAG are we required to accept?
Well, I could be cavalier in answering
Could you repeat the question? Just, I think some people might have had
I think
trouble.
I think the question, if I can just summarize it, is to what extent do we have to comply with the allocations that ABAG gives us? Pretty much.
No, beyond that. Apparently we have to comply with the allocations, but what beyond that do we have to comply with? Larkspur has 132 units allocated. Larkspur has 132 units allocated for the 2014 to 2022 period. And that seems like it'd be fairly easy to comply with. Do we have to go beyond that? Is there anything in these current acronym or
Acronym laden.
Yes,
Yeah.
yes, bills and statutes that require us to go beyond that 132 units?
And I think the answer to that question is not to my knowledge.
Oh, thank you.
And in fact, you know, when you say what are folks required to do, that's kind of a challenging way of describing what we're about here. What happens in the process is, as I understand it, and again, I'm more of an environmental lawyer than a planning lawyer, although I'm learning fast. Essentially, what happens is that you jeopardize opportunities for grants and for funding. So when you say required, well, you're required if you want the money. You know, Marin County, when it adopted its updated housing element last fall, you know, it gets transportation money if it goes through with that process, and it gets, as it did, its certification from the state. So if you want to say we don't want your money, you know, we want to back out, we don't want to deal with this process, then essentially you forego opportunities potentially to take advantage of what the process allows. But it's your choice. And you know, I emphasize again the importance of remembering this is a political process, and you all have elected officials who are responsible for this process. And land use is an inherently a local process in the state of California. So it's an inherently a process that will be decided by your city councils and by your county elected officials, not by Sacramento.
Yeah, okay. Yeah, I'm Nina Dennis. Excuse me, and I wrote my first DIR in 1971 before the Friends of Amity. I retired from that in 1998, and now I review them, you know, in the interest of the environment and the public.
Microphone.
Okay, sorry. So I have kind of a general CEQA question. You talked about two administrative processes, one of which is to get an adequate EIR, and the other of which is to get a project that you want. And between the two, there is often a moment or a period, or it can be months, between the certification of the EIR
That's
and
right.
the...
That's right.
Pardon?
That's right.
Yeah, right, and the merits of the project. And in between that time, you're asked to trust that the mitigations will in fact be converted into conditions, and that the findings will be made that actually make the promises come true. So how do you see bridging that gap? It takes a lot of trust on the part of the public to think that the EIR in fact is going to become inherent in the project itself as conditions.
Yeah, one of the reasons that I wanted to kind of separate, as you just did, and with your question, separate out the process of doing the environmental review from project approval, is because the processes are a little bit different, and they differ a little bit in the ways in which the public can engage the process. So, for example, I mentioned with the EIR for the stationary plan, we're going to have a public comment period that started now, and it will end. And under CEQA, the city will be required to respond to comments that are received during the public comment period. It doesn't have to respond to comments that it receives after the public comment period, unless there's a new public comment period, and that's always possible as well. But that's for CEQA. For the project approval, government agencies, and I don't know that we've all in Larkspur quite completely figured out what the process that we will be following for project approval or disapproval or whatever it is we decide to do there. But that process will continue after the close of the public comment period for CEQA purposes. And you're absolutely entitled to show up, to write letters, to communicate your views all the way up to the last day of the process that the city or whatever government agencies that is involved in the process decides to embark on. So you have that opportunity in the project approval process to make sure that, to the extent mitigations have been adopted as part of the CEQA process, to tell your elected officials that you want to make sure that those are incorporated into it. And I want to really emphasize that, because I have seen in other settings government agencies kind of mush together their obligations under CEQA and in project approval processes, and essentially say, well, if you didn't get your comments in during the public comment period for CEQA purposes, we can just forget it. And that's wrong.
Okay, next question over here.
Hello, I'm Jenna LaFleur from Larkspur. I'm Jenna LaFleur from Larkspur. I'm thrilled to have a CEQA attorney on the Larkspur City Council. I'm thrilled about
Thank you.
that. We've needed that for a long time, and we haven't had much compliance with CEQA for a long time. Most of the EIR options regarding traffic were always scheduled 0 impacts. And many, many other things. I'm just happy to have you here.
Well,
so
thank you. I
I'll be
appreciate that.
seeing you in the meetings. And the question I have is, did CEQA always apply to individual houses from the
No.
beginning?
No, it does not. Generally, does not apply to individual residential properties.
I heard you mention something about that.
No, in fact, there's a categorical exemption, I believe, that takes that residential, individual, single-family houses out of the process.
Okay, so my question
I
is,
hope that's right, because I was on the planning commission for a while. They kept telling us that was
I'm
right.
sure you know. I used to notice that someone would buy a parcel of land and then they would make a proposal to build upon it. And that proposal would have to meet the requirements of the city or the county, wherever they were located. Now it seems like the city has these special arrangements, special friendships with all the developers, so that they make a parcel. They make big parcels and big projects, 60,000 square feet here in Larkspur Landing in particular, 90,000 there and 180 there. And
I thought actually you were going to use a different example, but that's okay.
well, these huge, projects are it's not like it used to be now. So could you get to your question? Maybe what I'm just wondering is how that change came about, because we no longer have individual parcels coming along with a proposal. It's a big thing. We're going to get money from the government, the federal government, and we have to approve these monstrosity projects.
No, actually, we do have individual single family. Like I said, I was on the planning commission for almost 2 years in Larkspur. And virtually all of the things that we had to consider in planning commission level were one-off projects, We're just one-off single-family residents. I want to build a house, or I want to renovate a house, or I want to do this, or I want to do that. So that's actually the vast majority of what the city actually goes through. The difference is that large projects are treated differently under the law, and a more elaborate review process is required for large projects and for small projects. So when you read about what's going on in the newspapers and you see all this controversy about this big project or that big project, well, that's just because greater scrutiny is required in that context. And that's a good thing.
Okay, question from this table?
Hi, Carrie Stabner, Marin Water Coalition, Mill Valley resident. I was a number of years ago. I just wondered if you could comment on the CEQA process and how well it worked with regard to the desalination proposal by MMWD, and secondly, how well you think it's working with regard to the proposed use of glyphosate on our watershed. That, I think, has just completed the draft EIR, and they will go forward with I'm not sure, they're waiting for the consultant reports on that. And to date, we have spent approximately $500,000 on consultants with regard to spraying glyphosate on our watershed to combat non-invasive species. I know you urge public involvement in the CEQA process. Let me tell you, from having spent years following their proposed desalination plant, it's very hard to stay on top of the lengthy, complex process. And now they're about to begin on another one, which I personally, with regard to the glyphosate, feel that it has tremendous health implications for the entire, all the ratepayers in MMWD.
Well, I'm glad I'm not on the water district, for one thing. I haven't looked at the environmental review projects for the spraying. I know that's it's very controversial, and I have my own personal views about whether that's a good idea or a bad idea, which I can share with you, and you might guess what they might be. They're not all that positive. On the desalt plant, You know, that process, the good thing about that process is that it did get a lot of public attention, I think. I mean, it was in the press a lot. At least it was in the press that I was looking at least, for a long period of time. There were some technical problems with that project. The aspects of that project that I worried about more than anything else is taking the effluent and putting it back out into the bay. And
treatment.
Yeah, well, and an ancillary concern would be the power supply requirements for that kind of an operation.
Right, 9 times the energy is getting water through conventional sources.
Okay, let's go on
Yeah.
to another
So
question.
just we can maybe talk about more about those matters offline, but I completely understand the concerns that you have with both.
And
Carrie, we're going to go on to the next question.
Yes. In 1977,
You're going to tell me I haven't been speaking in the microphone.
Can you hear me?
Yeah, I can
Yes.
hear you.
Good. In 1977, the French government became puzzled by the increase in street violence, and they did a study, and they discovered that if you increase the size of the city or village beyond 20,000, the amount of crime starts going up exponentially. If you go above 200,000, you're in dead trouble. In other words, the number of people that you're required to relate to means that increasingly, as the size goes up, you cease to do so. The police can no longer cope because the citizens no longer do the policing. And it's very simple. It's not a question of density, it's a question of the sheer numbers. Now, Mill Valley happens to be at about the point that it shouldn't grow beyond. The whole of Marin is at the point that it shouldn't grow beyond. But unless this principle, which is in a chapter I published in this book about 30 years ago, and which the Lancet described as incontrovertible, and that's the Lancet, the English medical publication, unless we can stop thinking that growth is a good thing and recognize that we need to stop where we are, then we shall be in increasing trouble, and no amount of tax base, no amount of government help, no amount of subsidy, nothing will prevent the kind of chaos of the decay of personal relationships.
Hear, hear. I didn't hear a question a minute ago. So I don't have to say anything. Actually, can I just say one thing in response to that, though, since the topic for today is CEQA?
I'm sorry?
Since the topic for today is CEQA, one of the things you have to remember is that it's the California Environmental Quality Act. So when we're talking about impacts, we're talking about impacts that must be inherently environmental. Now, what constitutes an environmental impact is not always hard to or easy to sort out. And an example of that is parking. You know, the legislation that we got for Sacramento last fall kind of takes parking out of the calculus in terms of the evaluation of significant environmental impacts. There have been court cases that have agreed with that, but there also have been court cases that have said, well, you know, parking really is an environmental impact. It may not be an environmental impact per se, but when you add cars to streets and you have more people on the streets and you have pollution coming from their cars and you have, you know, other things going on, well, maybe they are an environmental impact. But, you know, crime is probably not an environmental impact, so it's probably not within the purview of CEQA. But lots and lots of things are, and we need to make sure we're focused on what those things are for purposes of the process.
Yeah. Hello, I have a question. Philip Richardson. Is there a project that was done in Marin that was done properly, in your opinion?
Not that I know of.
Justin Kai. My question revolves around, given that the state and the county, all of our government agencies seem to be increasingly trying to increase residential in what historically has been, my understanding, dangerous areas in terms of air quality, toxic air contaminants, this concentration in transit corridors. How is that possible? How are we seeing these residential projects pop up in these areas that are typically seen as a hazard to air quality for new residents?
Because somebody didn't do the CEQA process right. That's kind of the short answer to it. I mean, you know, if the public hasn't been engaged, and you know, decision makers make decisions that are bad decisions, then projects get approved, and they're not always good projects. And one of the challenges with CEQA, which I am acutely aware of since I do litigate CEQA cases, is they have a very short statute of limitations. You know, essentially, once you've got a CEQA approval, your lawyer has 30 days to get into court. And that's not a lot of time. I think that's about the shortest statute of limitation I can think of anywhere. So what sometimes happens is people aren't engaged in the process. There's an inadequate administrative record that is prepared to support views that people want to support, that people figure that out too late, and then all of a sudden there's the 30-day statute of limitations is expired, and you're stuck. So that's how it happens. The CEQA process didn't work.
So Kevin, could you comment on that in regard to Wind Cup and the fact that it was built on property that had been a former styrofoam cup manufacturing plant, and how it help us better understand how there was not an environmental impact report for that? Or maybe not.
I think I and many people have concerns with how that project got approved. And one of my concerns, and I think a concern of the Larkspur City Council, which I think I can say because we've started an ad hoc committee within the City Council, not to focus on contamination issues, which I think your question was going at a little bit, but more to take a look at how traffic mitigations were adopted. Because Wind Cup is spitting distance from the boundary between Corte Madera and Larkspur. And Larkspur will bear a significant part of the consequences for that. But to answer your question, I don't know. I'm still trying to figure that out. And one of the reasons that I'm glad that our city council did appoint an ad hoc committee, of which I am a member, is that we're at the very least going to take a hard look at those traffic implications.
Hi, I'm Bob Silvestri. I live in Mill Valley. I just wanted to add a couple comments. This thing about there's money, and that's why, you know, the choice of you take the money, do the development, whatever. I want to put some facts on the table. MTC was given $268 billion by the federal government to allocate under Plan B area. Billion? 90% of the $268 billion, billion with a B. 90% of that money, they forgot to say, is already allocated to projects that are under construction or existing highway maintenance. That leaves about $16 billion. 90% of the $16 billion already goes to projects that have been approved over the last 10 years but haven't started. That leaves $1.6 billion for the entire San Francisco Bay Area. Now, the subway in San Francisco would take all of that if they could. This is why in Marin, we only have pretty much all the money going to 2 PDAs, which is less than $1 million in total. So there is no money. This is not significant money. $261,000 in Strawberry wouldn't pay for half the cost of the consultant to do the traffic study that they were supposed to do. There is no money. This is a Trojan horse. The second thing is that what no one seems to understand in the cities, which I just put out there for consideration, which I've talked to with executives in ABAG many times, is there are no conditions on the money. In other words, there's nothing stopping any city from saying, okay, give us an OBAG grant, which comes through TAN, for $300,000. We're going to do a study on traffic. After we finish the study, we're going to say, you know what, we didn't like the result of the study. We're going to remove the PDA, remove the designation, cancel the project. There are no reparations. There's nothing in the law that stops you from doing that, and even doing it in a premeditated way. Okay? And this I have on authority from the highest levels in ABAC. There's nothing stopping you. So the cities haven't been very clever about leveraging for the benefit of the communities what they could do. The last comment I'll make about that is that there's been this pushback where Strawberry said, we don't want the money, Marin Wood says, we don't want the money, or Bree says, we don't want the money. Actually, this is working. And the way it's working is, we have to understand that politics is very strange. Somebody got hired to do a job at MTC to give away money. If they can't give it away, that's called a failure. When you fail, you lose your job. And in fact, there are conversations at the executive level at MTC and ABAC right now reinterpreting SB 375 to come up with other ways to think about this so that they can give the money away. Because they don't want to give it all to San Francisco, San Jose, and Oakland that want all the money. So it's just an interesting world. I just want to add that.
I'm glad there wasn't a question there either.
Let's see, we've got time for just maybe 2 more questions. So let's see, Clayton's had his hand up, and then we'll get one more.
Yeah, Clayton Smith. When I got a notice of the fact that the station area plan was the 60-day clock was running, I think it was April or the end of March. And the first major public meeting is going to be May 22nd, which is just about 6 or 7 days before the end of the 60-day clock runs out. And it seems to me to be pretty a date selection that is pretty disingenuous as far as the interest of the parties involved to have public input. The second thing is that when the first the station area plan ideas were brought out in Larkspur in the winter, when confronted with the fact that there was no input in the presentation concerning the impact on traffic on Highway 101, the traffic consultant David Parisi, I pressed him on this pretty forcefully, made the comment that he left the information at home. So I have two things I'd like to ask of you, which is to perhaps accelerate and bring forward in time the first public meeting for the general public, and maybe have more than one. And secondly, would you please make Mr. Parisi bring all the information to the meeting so we can actually have a conversation. Thank you.
Actually, I just wanted to just say 1 or 2 things in response to that. On your second point, yes, I'll do that. I do want to emphasize again that I'm not speaking here today in my capacity as a member of the City Council, and I can't represent the views of the City Council or City staff on some of these matters. We're starting in a process. We're learning to some extent as we go with the process. What I will offer, though, is just a fact that we have a 60-day public comment process as opposed to a 30-day public comment process because I asked for it. And I also asked that we start the public comment period after the EIR was already issued, as opposed to what often government agencies do, which is to start a public comment period, often for 30 days, beginning on the date that the EIR comes out. It's my view as a general matter, not just with respect to Larkspur, that it's important to provide the public with ample opportunity to review these very complicated, thick documents and to develop intelligent, responsive comments on those documents. I don't know, because I didn't set the date for the hearing, so I don't know exactly what the rationale was for putting the date when it was. But I will say that the principal point of the public hearing component of the public comment period is to receive public comments. Those public comments are probably going to be better and more thoughtful if they are submitted later in the process than earlier in the process. Now, maybe it would be good to have, multiple times, but the real point of that hearing is to receive comments on a document that it's going to take you that long to read. So, I would encourage you to take the time between now and that hearing to read and to talk with your neighbors and to talk with your friends about what it says and to formulate the questions that you have in your own mind about issues that you think the document raises. And then come to that public hearing in May, or whatever date it is, armed with those questions and armed with those concerns, and articulate them. And also, write them down. Write letters. You can write a letter today. If you've done what I have, which I haven't done yet, if you've already gone through that AEIR, then you can write a letter today, and it will be included in the administrative record. So take advantage of the opportunities that are there. Frankly, the best way of communicating concerns is in writing, because you only have a limited amount of time in a public hearing process. And there's going to be a zillion people showing up at that public hearing, I can tell you that.
Okay, I know there's lots of hands still up. I'm going to take time for one final comment, and then we're going to wrap up.
Thank you very much. My final comment seems like he can be, but he can explain better than me. Susan, please, let me give you. He can explain better than me. Thank you. Thank you very much for your work. Very good.
Yeah, I just have a short question. You were talking about...
Would you stand, please?
Yeah, sure. Vic Canby. With environmental impact reports, the scoping process is very important. With your expertise as an attorney, can you tell us how the scoping process occurs and how people are chosen to get involved in that process?
Are you asking specifically with respect to the stationary plan, or just as a general matter?
Just as a general matter. Tell us how the scoping occurs.
Well, I usually think of scoping as not quite so much a CEQA process, as more just a development of a proposal process and sorting it out. And what, excuse me?
This is totally CEQA.
Well, I guess that's right. I stand corrected on that. We have, let me give you, for example, what we did with the stationary plan. We engaged consultants to focus on the project description, among other things, which they did. And we had a process that went on for a period of months that included the involvement of a Citizens Advisory Committee, of which I was a member, where we would hear proposals, suggestions by the consultants for what they considered needed to be scoped out for purposes of that project, and we provided them with feedback. And we got to the point where we concluded that we'd given them enough feedback to kick the process on beyond the scoping phase and actually have it go into the political phase, where it'll be subject to public review and comment and a decision by the Larkspur City Council. So I think that's pretty much the way it is supposed to work. Now, not everybody's going to agree with what came out of that process. In fact, I think most people, or many people, don't. But that's why we're now in the political process, and it was important to conclude that process, that preliminary scoping process, when we did, so that we can move on. And that's what we're in the process of doing now.
Thank you, Kevin. And I want to acknowledge all of you who have great questions that I wasn't able to get to. I'm so sorry there's not more time to continue this. I expect Kevin might be here for a few minutes afterwards if you have informal questions. Please, a big thank you to Kevin for all of the thoughtfulness around this topic. Thank you so much. Thank you. We have for you our appreciation. You may need this, a little bottle of wine, either after this meeting or after one of the many meetings. I want to call for a motion. Is there a motion to adjourn this meeting? So moved here from Eva. A second? Okay, we're officially adjourned. Thank you all so much for coming out today. Please come back in May. You're welcome to stay and mix and mingle and continue with this important conversation. Thank you all. Bye.